Good morning, ladies and gentlemen. I am delighted to be invited back to the podium after a long, very long hiatus. I am afraid, however, that I have the proverbial good and bad news. I know that many of you are expecting something different from me. After all, you've heard me recite poetry. You've heard me perform the arbitration bang. You've heard me scream out that cri de coeur, the management labor lawyer rant. Oh, by the way, all of those things, despite my protestations to the contrary, are on our firm's website and are apparently accessible by clicking on the link. And I'm told that there have been so few hits on that link, and the only people who've gone to it are my kids' friends when they're at a party some night, late in the evening, no doubt illicitly drinking, and really arguing over whose dad is the biggest loser and the least cool. And apparently I have won that award repeatedly year after year. In any event, I had planned something very au courant for today's presentation. It was going to be, and there were a lot of requests to this effect, it was going to be a Griever Gangnam style dance routine, and it involved half of the firm's associates. But I have to tell you, we worked so hard and practiced so hard that, in fact, I developed laryngitis. It's just coming, my voice is just coming back now, but my singing laryngitis has kicked in, and I'm afraid that enterprise will have to be aborted. Hence the good and bad news, because I know that most of you will be delighted that you will be spared that ignominy, and there's a very small number of you who share my pain and disappointment. So I guess that just leaves an introductory joke. Again, I have a problem, because many of you will remember that I think it was 4 or 5 years ago, I told the world's greatest joke, as it's affectionately known in my household, the duck joke. And as you know, the duck joke is so good that all other jokes pale by comparison. So I can't do that. But I know that a lot of you are animal lovers, and sticking with the theme of ducks, I do want to tell you a true story, and I think it also involves medical reports, so as HR practitioners, I think you'll enjoy this. It's just simply a true story that I hope you'll find interesting. I'm a bit of a bird lover. In my own mind, I'm an amateur ornithologist, and my kids are aware of this, so for my most recent birthday, they gave me a bird feeder. And it was a really good one, because as soon as I filled it up with the seeds, I took it out in the back deck, and birds started coming around, including the beautiful red cardinal named Rosie, who lives in our backyard. And Rosie was so excited that Rosie, not watching where he's going, flew right into the back porch window, fell to the porch, and wasn't moving. So I scooped up Rosie. I took him to a veterinarian, emergency veterinarian. I said, "Doctor, you got to help me. Rosie, you got to do something." And the veterinarian looked at him and said, "This bird is dead." And I said, "No, Rosie's not dead. He's just knocked out. You've got to do something." So he let out this whistle, and in came these 2 Labrador retrievers, and they came in with their tails wagging and walked up to the bird. You know, and they were very excited. And then they walked around a couple of times, pawed it, and then they just dropped their tails and went out. The doctor said, "See, I told you, this bird is dead." I said, "No, it's not. It's just knocked out. You got to do something." I said, "Okay, I'll try something else." So he brings in this cat, and the cat comes in, and and I'm not a big cat fan, but it sort of superciliously walks around the bird, looks at it from one angle, and goes the other side, looks at it from the other angle, and then just sort of strolls out in a disinterested, haughty manner. So I said, I guess the bird is dead. So do I owe you anything for that? And the doctor says, "That's $500. I said, "What? You didn't do anything. This bird is dead." He said, "But once you asked for the CAT scan and the lab work, the price went way up." All right, it's not the duck joke. All right, so that leaves me about 6 minutes. And by the way, my laryngitis is so bad that, in fact, I'm not actually speaking to you today. This is pre-recorded, and I figured if Beyonce can do it, I can do it. So, the title of my paper is Unlocking Keays, the latest on bad faith damages and wrongful dismissal. And I'd like to thank our associate Bonnie Chan for her help in the preparation of the paper. And this month marks, in fact, June 2013, marks the 5-year anniversary of the release of the Supreme Court of Canada's seminal decision in Honda versus Keays. So what did this case do to the law? Let me just sort of summarize where we are. It attempted to sort out a lot of the common law concepts that you're all familiar with: Wallace damages, bad faith damages, reasonable notice, aggravated damages, punitive damages, independent actionable wrongs. You're all familiar with these terms. And Wallace was a case that basically established upon employers a duty to act in good faith in the manner of termination. So let me step back a bit. The employment relationship, as you all know, is a contractual relationship, and it's trite law that in the absence of just cause and in the absence of any legally enforceable employment contract provision, an employer can terminate an employee on reasonable notice or compensation in lieu. And typically in Ontario and cross-common law jurisdictions in Canada, reasonable notice ranges from 3 to 24 months, having regard to the main factors of age, length of service, position, and salary. And historically, at least, the courts steadfastly maintained that things like pain and suffering or mental distress associated with the fact of the employment termination in and of itself were not compensable. Quite simply, because the employment relationship is contractual in nature, and because the parties must be deemed to have contemplated the termination of that employment relationship, you can't get damages for pain and suffering from the termination in and of itself. Then, as you all know, things went a little wonky, for lack of a better word. In 1997, when the Supreme Court of Canada released its decision in Wallace. And it essentially took 11 years until the Supreme Court of Canada's 2008 decision in Honda versus Keays to sort of place the law on a more coherent framework. And I would summarize where the law is now as follows, and I'd sort of distill it down to 4 basic principles. First, the purpose of aggravated damages is to compensate the employee for intangible losses arising from the employer's behavior, non-pecuniary losses arising from the employer's behavior, such as mental distress, hurt feelings, and so forth. So that's what aggravated damages are. They're compensatory. On the other hand, by contrast, punitive damages, also sometimes referred to as exemplary damages, are non-compensatory. That is to say, they are intended to punish the defendant employer for harsh or vindictive conduct that is unacceptable, really that, when it comes down to it, offends the court's basic sense of decency. They are almost always sought, as you know, by plaintiffs, and almost always never granted. So that's the first principle. The second principle is there is no longer a distinction between so-called Wallace damages, which used to result in an increase or bump up in the reasonable notice period where the employer engaged in bad faith, and aggravated damages, which I've just explained. The question in every case is, are the damages reasonably foreseeable, and are they deemed to be within the contemplation of the parties as a result of the breach of the employment contract? That's the second principle. Third, in addition and separate from reasonable notice, an employee can claim or seek these compensatory or aggravated damages for bad faith in the manner of termination. But this is the key now. Plaintiff can only seek these aggravated or compensatory damages if, and only if, the manner of dismissal, the bad faith manner of dismissal, results in actual or provable mental distress suffered by the employee. And then if that occurs, the damages awarded will be proportionate to the injury suffered. In other words, it isn't good enough to prove simply bad faith in the manner of dismissal, which was really the law of the land in the pre-Keays Wallace era. Back then, if an employer engaged in bad faith, a court would just routinely increase the reasonable notice period from, say, 10 months to 15 months or some other period. Now you have to prove the bad faith and that bad faith caused real-world harm. And employers are still subject, by the way, to the Wallace concept of the duty to act in good faith. That's still there. It's just that automatic damages for a breach don't flow anymore. Then the fourth principle I would articulate is that punitive damages, which, as I've said, are non-compensatory, should only be awarded in the most exceptional and limited circumstances. And in fact, the Supreme Court of Canada said that they should only be awarded where the courts of the view that the aggravated compensatory damages are not adequate to bring home to the defendant employer that its conduct was inappropriate. As well, with respect to punitive damages, you must still have this independent, actionable wrong. So that's where that concept comes in. And an independent, actionable wrong needs to be something other than simply a breach of the employment contract. The most common claims put forward are some sort of tortious action, like intentional infliction of mental suffering or something like that. Okay, so those are the four basic principles that really reflect the law of the land now. Since Keays came out in 2008, probably the central question that has sort of been grappled with by the lower courts is how are they going to deal with the Supreme Court of Canada's framework put down by Keays, and how difficult is it going to be for plaintiffs to actually get awarded these aggravated or compensatory damages for a breach of the duty of good faith. And by the way, just to step back for a moment, hopefully you all know what breach of the duty of good faith is. There is no set definition of what is good faith. It's assessed on a case-by-case basis. Obviously, humiliating an employee would be bad faith. Recklessly and without any foundation asserting just cause could be bad faith, defamation, and so forth. There's really no end to the possibilities. What emerges from the case law over the last 5 years, I would say, is this. First, in most cases, courts will expect to see evidence of actual medical attention or other appropriate professional treatment by the plaintiff. That could be from a psychologist, that could be from a family physician who provides psychological counseling. There has to be some evidence of proof of the mental distress. That's one sort of trend that we're seeing in the decisions. Second, in a few cases, the courts have gone even further. It's not good enough to establish mental distress. You also have to establish that the mental distress was caused by the employer's bad faith. And that's harder than it sounds. I mean, there was one case that's reviewed in the paper where a physician was escorted in a humiliating fashion out of the workplace by a security guard, and bad faith was found. But because there was no evidence of mental distress caused by this action, damages were denied. On the other hand, and thirdly, I guess I'd say, some of the courts ignore all of the Supreme Court of Canada's framework and simply say, and almost take judicial notice of entitlement to Wallace damages if there's bad faith. And in my respectful view, those decisions are wrong. It's just they quickly jump to a conclusion that bad faith has caused distress and to the worker, to the employee, to his or her family, and so forth. So to sum up, this has been an academic presentation. None of you as clients of Filion, Wakely, Thorpe, and Giletti have ever engaged in bad faith in the manner of termination. So really, this is not anything you need to worry about. Thank you very much.